hello everyone. We have the next episode of interviews dedicated to the Eastern European Dispute Resolution Forum. And today we have a great speaker, Yelena Stasyk, who will be speaking about document production and its role in international arbitration. I would like to introduce myself. My name is Yaroslav Petrov. I'm partner of Asters Law Firm in Kyiv, and I'm also member of organizing committee of the Eastern European Dispute Resolution Forum. So it is a great pleasure for me to have Yelena at this interview because we have known each other for a number of years, and first we met in Kyiv, and then after some time I have discovered that she has been developing a great career in France, and it is a very important and interesting to see how Ukrainian lawyers can be successful not only in Ukraine but also abroad. Yelena has very significant experience in international investment arbitration, and she has been working both in Ukraine and in France, and she is dual qualified. And in Ukraine, her work was related not only to arbitration but also to banking finance matters, PPA matters, and other issues. But in France, she has been focusing mostly on investment arbitration. So Yelena, we're very welcome to see you at this interview.
Thank you very much for such a presentation. A lot of kind words to hear. Thank you, Yaroslav.
And we have a very important topic today to discuss, document production, the topic which is not very often discussed in Ukraine by Ukrainian legal practitioners, taking consideration how our legal system is based. And I really appreciate that we have opportunity to discuss it with you because we have you can tell us from both sides, from the perspective of Ukraine, how we can look into this, and from international angle. And I am sure that our discussion will be very interesting. And to start with our discussion, I would ask you to answer what does it mean for you, document production? Is it a necessary evil, or it is a key factor for winning arbitration?
For me, document production is one of the key factors for winning arbitration, because sometimes it's the only way to procure the required evidence or information from the opposing party. However, in order to be effective, it should be well structured and well thought in advance. Otherwise, it's going to be transformed into a necessary evil that will require a lot of costs and will take a lot of forces from the council and from the party, and will take forever to be completed.
Thank you. And as I mentioned, that there may be some peculiarities of regulation document production in different legal systems. And what is your view on how we should look into the document production as common law lawyers and civil lawyers, and how to reach a balance between these aspects for lawyers who are working in this jurisdiction?
Indeed, it is considered that as document production originates from a discovery, and discovery it's an inherited procedure that is familiar to every common law lawyer. So they have certain privilege because they know and they have experience how to use this stage, while the lawyers from the continental system, they are not so familiar with this type of proceedings. However, I think that in international arbitration, there were already certain steps taken to kind of remove these imbalances by means of creating soft law instruments that are available now. So we have two main soft law instruments. It's IBA rules and the Prague Rules. They are aimed at creating an even legal field that with clear, let's say, guidelines how parties should behave to remove such imbalances. And in addition, I think that it's very important to take into consideration possible imbalances between different legal backgrounds while creating a team of lawyers working on a matter. If the team is really international and consists of both civil law trained lawyers and common law trained lawyers, it will be only beneficial for the client because in such way we remove all the imbalances, and moreover we have a team with different legal cultures, different views, which can be only beneficial.
You mentioned about soft law instrument for document production, and one of the new instruments is Prague Rules. What is your view on this document? Whether it is helpful for document production and whether it impacts cost efficiency for parties?
Unfortunately, I didn't participate yet in any arbitration where parties selected the Prague Rules as guidelines. But for me, both IBA rules and Prague Rules, they are created, as their respective working groups said, they're created to improve the cost efficiency of the arbitrating proceedings and make them shorter. It's a soft law instrument that creates, as I already said, an even playing field. It gives guidelines how to behave, what to do, but then the parties have always a choice how to behave and how to respect certain rules. So any party can decide to take a guerrilla's approach and apply different guerrilla tactics and ask for delays, involvement of the expert for any small issue, and this will be reflected in considerable costs. Therefore, we cannot blame the rules for such a behavior of the parties. However, in this type of situation, the party who decides to apply these bad faith approaches, can be said, this party should always remember that the current practice foresees application of the negative interference, and the party that suffered from such an action could always ask for the costs to be reallocated on the party who were not behaving in a proper way.
Yeah, saying about guerrilla tactics, there have been proposals with respect to changing the role of arbitral tribunal, and whether you think that additional powers to the tribunal will be helpful to avoid such guerrilla tactics during the document production stage.
Indeed, for a long time there were certain discussions that because the tribunal doesn't have an active role, parties can engage in different types of guerrilla tactics, and there were a lot of proposals how to improve the situation. Certain of these proposals were taken and already reflected in the Prague Rules. As it's a very new instrument for the moment, I don't know how they are implemented in practice, but at least the tribunal has a really active role. It starts with case management that should be scheduled without any delay. It should be in a more efficient format. It should be through a meeting, online meeting. And then Prague Rules, they also gave to the tribunal the right to inform the parties on its view with respect to allocation of burden of proof, with respect to certain facts that it considered to be important for the case, and also with respect to the documents and witnesses that a party should produce. How it's going to work in practice, we don't know, because it's an inquisitory approach, more fact-finding approach, which is relevant for civil law jurisdictions. So it would be interesting to see how it's going to be implemented by the tribunal, which consists of majority common law lawyers, because it's something that is unknown for them. And another view on this proactive role of the tribunal is that arbitration in itself is interesting for the parties because it's a freedom to choose how to present arguments, how to express its points of view. We have guidelines, but then it's for the parties to decide how it's going to happen. And certain practitioners consider that taking the power from parties to the tribunal, it makes arbitration less interesting because it's it makes it in certain terms more prone to behavior of the state court. But for the moment, we don't have much information about it because Prague Rules, they were adopted in 2018, if I'm not mistaken. Yeah. So we don't have much cases to study.
Yeah, we'll see how it will develop. And from your perspective, do you think that attorney-client privilege is used sometimes to abuse document production in arbitration?
For me, attorney-client privilege is like one of the most important factors and privileges that should be respected by all the participants of arbitration proceedings. Indeed, sometimes it is used by a party as a way to escape production of documents. So here we have kind of a deadlock. From one side, it's a privilege that should not be disturbed. From the other point of view, sometimes it's something that is used to cover documents that are not covered by this privilege. So in certain situations, it's important for the party who requires the production of documents to ask for more information with respect to these documents. I'm not talking about disclosure of the content, but at least to explain why this document is covered by attorney-client privilege, explaining whether a person is admitted and is considered to be an advocate, because for instance, in France, everything that is done by just a lawyer of the firm is not covered by attorney-client privilege. You need to be admitted to the bar to have the document be attributed this special status. Mm-hmm. However, in certain jurisdictions, there are certain questions with respect to whether a document sent, for instance, by a secretary of an attorney is covered by the privilege. And that is why it's important, while saying the objection to produce, to be able to explain it in legal terms with reference to respective legal documents, why this document is covered by attorney-client privilege. If it's not possible, then the document should be disclosed.
Great. And I have a question with respect to situation when sometimes parties are trying to do a massive document production. And do you think that it may be used or it is actually intentionally used to hide some of the evidence?
I think that this is the less effective guerrilla tactics, production massive amounts of documents, because maybe before when you had only lawyers and like paralegals and assistants and you received 10,000 documents, it's hard to process. But now we have different kind of software that helps a lot to identify certain documents, to do a pre-selection of documents that are not very important, that should be, for instance, reviewed at the end, or the documents that contains, for instance, certain keywords. Therefore, I don't think it's a very efficient strategy to cover up for some documents that make sense for the case, that are very interesting for the case to prove the position of the party who is requesting the production of such documents. In addition, as lawyers, we're paid to review all the documents, and we must act in the interest of our client, and therefore, anyway, we're going to process these documents and we're going to see if there is something interesting to prove our case. And also, this is one of examples when a party who suffered from this type of actions can ask for negative interferences, and also to ask to allocate at least these costs to the party who was not properly behaving and produced massive amount of documents. And another thing that I also want to tell with respect to such an issue as this was my position with when you are a party who are receiving a massive amount of documents. But then another position, it's that fishing expedition and massive production of documents, it's very subjective term, which is, let's say, in the eye of beholder. So if the request is very widely formulated, maybe it's not that massive amount of documents that are produced, maybe it's a reasonable amount. So we need to check it also with respect to request.
Yeah, I see. And what recommendation you may offer in order to improve document production mechanism for arbitration? What would be your suggestion?
For lawyers working on document production, I think it's, as I said at the very beginning, that document production should be well structured and well thought in advance. You should start thinking about document production when you first talk to a client, because after this conversation, you can see whether you have sufficient amount of evidence to prove your case, whether you need something in addition. So you can already decide whether you want a broad document production or a limited document production. At this stage, you can also decide whether you have sufficient amount of documents, for instance, to draft a request for arbitration, to draft the memorial. Because sometimes you don't have sufficient documents and you can already ask the tribunal for so-called mini document production. This is not an ordinary case, but at least you can ask for it. The second thing to think about is the selection of an arbitrator. The party should do its intelligence and should select an arbitrator taking into consideration his or her background, his or her approach to document production, which is often said during different conferences and also in different articles. And the next step would be discussion with the opposing party to select the soft law instrument that will supplement institutional rules that is most suitable for the case, and different templates that are going to be used. And the last one would be preparation of the document request. It should be well thought in advance. It should be very precise. And respectively preparation of the objection to refusal to produce certain documents. I think these are the main steps to make document production efficient.
Thank you. It is very important recommendations for us. Now we're moving to a quite interesting part of our interview. It is express 10 questions which we ask, and we give 10 seconds to answer. So you should focus and concentrate now on this 10 important questions. So the first question is, in Ukraine, you work not only in arbitration sphere, correct?
In fact, in Ukraine, I didn't work in arbitration at all. I used to work in real estate and with private-public partnerships.
Great. Have you practiced law more in France or Ukraine?
If we're not taking into consideration the internships that I did in both countries, I think I practiced for 6 years in Ukraine, and it's my 6th year in France.
50-50.
Yes.
How would you like? How would you describe in 3 words practicing law in Ukraine and in France?
In Ukraine, I would say constant changes, rapidly changing law. In France, I would say it's more evolutionary approach in terms of changes to the law and gradual changes.
What is your philosophy when it comes to representing clients?
My philosophy would be to protect the interests of the client with all available and possible ways.
What is your greatest triumph in your legal career so far?
I think for me, it was the last year when I practiced in Ukraine. It was 2012. I was nominated for Legal 500 Ukraine in real estate and IPO.
Great. Tell me about a complex legal issue you work on and describe how difficult it was.
Interesting and complex legal issues always arise when there is a question of representing the client and trying to prove your point of view, and the question of deontology, which should always be taken into consideration. For instance, as a French lawyer, you are not allowed to produce any exchange with another lawyer if it's not specifically allowed at the time when the letter was sent. So it's always very important to take into consideration with whom you are having exchange, what should be a mandatory mention there in order afterwards to be able to use these documents. And sometimes it requires a certain legal expert opinion. And in France, we have bâtonnier, who is the first among equals attorneys, and he gives his opinion with respect whether it complies with the deontological rules or not.
Fair enough. Question was difficult. You took more than 10 seconds. And what is for you document production? Is it an essential element of justice or just a waste of money and time?
For me, as I'm working on like big cases, and cases that sometimes are concern certain facts that happened, for instance, in 19th, it's the element of justice in terms of it's the only way to procure certain evidence that were either destroyed or lost or not kept.
Mm-hmm. What was the funniest story in document production in your career?
This would be easier because I didn't have any funny stories in document production. It's normally it's very like smooth going stage.
What should not be done at this stage?
At document production, I think, as I mentioned, parties should anyway act in good faith. So they should avoid doing like fishing expedition and messy production of documents just to make the case last.
Mm-hmm. And the last question, have you seen fake documents presented during the document production stage?
We didn't experience this during the document production stage, but once we had a fake document produced at the hearing.
Well, thank you very much for this interview. It was very lovely and interesting. Thank you very much.
Thank you very much for your invitation. I'm very pleased to be one of the speakers at this event. Thank you.